Good morning, everyone. Welcome to the S3VIAP Breakfast Fireside Chat with the Honorable Judge Charles N. Brower, which will also feature an introductory speech by his former law clerk, Jeremy Sharpe. My name is Sunita Advani, and I'm the founder and chair of S3VIAP, which is short for Singapore Very Young Arbitration Practitioners. And I'll be moderating today's fireside chat with Charlie. Today's fireside chat will delve into Charlie's remarkable life and distinguished career at the front lines of international justice, drawing inspiration from his recently published memoirs, Judging Iran. We are extremely privileged to have Charlie and Jeremy with us today, both of whom need no introduction. Charlie is the senior-most arbitrator member of Twenty Essex. His 60-plus year career in the law has combined extensive practice at the bar with distinguished public service, both national and international. For over 40 years, he has focused on public international law and international dispute resolution. As counsel or arbitrator, he has handled cases on all 6 continents, principally under the rules of the ICC, UNCITRAL, LCIA, AAA, United Nations Compensation Commission, ICSID, Stockholm Chamber of Commerce, Insurance and Reinsurance Arbitration Society, and LMAA. These cases have involved a wide variety of commercial disputes, as well as issues of public international law, particularly involving the oil and gas sector, major infrastructural projects, expropriations, and other investment disputes, including ones arising under both bilateral and multilateral investment treaties. Charlie started his career with White & Case in New York, before serving for 4 years in the United States Department of State in Washington, D.C., concluding as its acting legal advisor. He then rejoined White & Case, co-founding its Washington, D.C. office, where his practice came to be comprised almost exclusively of substantial international arbitrations. He has served continuously since 1983 as a judge of the Iran-United States Claims Tribunal in The Hague, the Netherlands. That service was interrupted for some months in 1987 by White House service as Deputy Special Counselor to President Ronald Reagan. Charlie resumed partnership in White & Case from 1988 until joining Twenty Essex in 2001. From 2014 to 2022, he also served as judge ad hoc of the International Court of Justice in 3 cases, as a result of which he is the most appointed of the 5 Americans ever so appointed. In 2015, Charlie was only the 4th ever recipient of the Global Arbitration Review Lifetime Achievement Award. Jeremy is an international arbitrator, international law consultant, lecturer in law, and senior fellow at the International Claims and Reparations Project, ICRP, of Columbia Law School, and member of the board of the United Nations Register of Damage caused by the construction of the wall in the occupied Palestinian territory. He previously was a partner in Sherman and Sterling's international arbitration and public international law practices in London and Paris, counseling private and sovereign clients on diverse matters of international dispute resolution, public international law, and international investment law and policy. He previously served as Chief of Investment Arbitration in the Office of the Legal Advisor at the U.S. Department of State, Legal Advisor to the U.S. Embassy in Baghdad, and as an Attorney Advisor in the State Department's Office of African and Near Eastern Affairs and Office of International Claims and Investment Disputes. He also previously clerked for Charlie at the Iran-United States Claims Tribunal in The Hague. Before we begin the fireside chat with Charlie, I would like to say a special thank you to our generous sponsor, Twenty Essex, and I would now like to invite Jeremy to deliver an introductory speech. Jeremy, please.
Well, thank you very much. Good morning to you all, and good evening, Judge Brower. It's a real honor to be here. I appreciate the invitation and kind introduction. I first met Judge Brower over 20 years ago in early 2001. As Sunita mentioned, I was his law clerk for 2 years at the Iran-US Claims Tribunal, and I had the opportunity to collaborate with him in the more than 20 years since, writing articles, book chapters, even one book with two of his other law clerks. And I've benefited immensely from his mentorship and friendship over the years. So it truly is an honor for me to be here today. When I first read his book, Judging Iran, which I highly recommend, it's very readable and very interesting, I learned quite a few things about his life and career that I had not known, despite having known him so long. I guess such is the richness of his personal and professional life over the years. That said, many of the themes of the book really seemed quite familiar to me, as they probably seem familiar to those who have known Judge Brower. Let me just mention three this morning that resonated with me. At first, there's a message that he learned from his father. I don't recall if this particular quote is in the book itself, but I think the sentiment certainly is. And it's something to the effect that few people succeed in life unless a lot of other people want them to succeed. And to my mind, this lesson reinforces the need not just to find mentors, but to really cultivate professional relationships, the professional community, which I commend this organization for helping with that. Having gone into practice, independent practice myself 4 years ago, I can attest to the fact that whatever success I've had is largely due to the success that others have wanted me to have, not least Judge Brower, who is quite famous for the support of his former law clerks and others. A second lesson in the book concerns the arc of one's career. And if we look at someone at the pinnacle of success, it's easy to chart a straight line of accomplishments. And certainly one could look at Judge Brower's career, as Sunita mentioned, having been made a partner at White & Case at a young age, rising to acting legal advisor at the State Department in a very short time, being appointed a judge of the Iran-US Claims Tribunal, receiving an important position in the Reagan White House, rising to become a top international arbitrator, judge ad hoc at the ICJ and other international courts and tribunals. It's not hard to see a steep and continuous line of achievements. But as Judge Brower discusses in his book, and as he's pointed out over the years, several important positions he received came after he was not selected for another position he was going for. And this theme resonates with me particularly because my career in international law started exactly the same way. As I said, I met Judge Brower in 2001. I was applying for a position at the Iran-United States Claims Tribunal with another judge who was on the West Coast. Judge Brower interviewed clerks, potential clerks on the East Coast for that judge. I ultimately was not selected by that judge for a clerkship. And naturally, I was very disappointed at the time. As you can imagine, this is something that I really wanted. But then a position came open to work with Judge Brower a few months later, and I was selected for that. And of course, it's a real, looking back now, it's a real blessing in disguise that I was not selected by the first judge and I had the opportunity to work for Judge Brower. I think these kind of experiences help us cope with the inevitable challenges in our careers, and they help us understand that long careers come with many setbacks, but also many opportunities. And the final theme that resonated with me with the book concerns Judge Brower's willingness to take risks and pursue new opportunities. His colleagues at White & Case must have been shocked when he resigned his partnership just a few months after he was made partner at White & Case to join the State Department when President Nixon was elected. And I think his decision to pursue international arbitration in the 1970s probably seemed rather quixotic. It now seems quite prescient, but certainly was not obvious choice in the United States in the 1970s. But I'm reminded of the words of the late David Caron, who was Judge Brower's first law clerk at the Iran-US Claims Tribunal, and he spoke of streams of history. David said, when he went to law school, it was to pursue his passion for environmental law. And he did, in fact, end up pursuing environmental law. But while he was at law school, the Iranian Revolution occurred, the hostage crisis, and which ultimately led to the establishment of the Iran-US Claims Tribunal, which he called a stream of history. And although these events didn't impact him directly when they were happening, he stepped into this stream of history. He applied and accepted an opportunity to work with Judge Brower, and it sent him on a different career trajectory, becoming one of the most eminent international adjudicators, from investor state dispute settlement to the United Nations Compensation Commission, judge ad hoc at the ICJ, becoming a judge at the titular judge at the Iran-United States Claims Tribunal, and so forth. So if you read Judge Brower's memoir, I think you see his career, or at least I see his career, as an object lessons, jumping enthusiastically into the streams of history, even when at times the currents may not always seem to be flowing with you. So as I said, I really encourage you to read his book. I thank you, Sunita, for the opportunity to be here, and I look forward, as always, to hearing your remarks, Judge Brower.
Thank you, Jared, for that lovely introductory speech. And without further ado, let's jump right into the fireside chat. I just want to let our in-person audience know that there will be an audience Q&A round in the last 10 to 15 minutes. So you can either submit your questions on Slido, or you can just raise your hand later and ask your questions. For those joining us online, you can send in your questions on Zoom via the Q&A function. So our first question for Charlie is, you write in your memoirs that your first year in law school was an academic disaster, but you were able to turn things around and build an illustrious career. How were you able to do that?
Well, first of all, I want to thank you, Sunita, and Jeremy for those very kind introductions and what I had, I guess, contributed to the lives of others. Jeremy being practically the first in a long line. Starting in 2000 or 2001. Well, it was a miracle, and it was because somebody cared. I couldn't get a job being interviewed in the beginning of my second year of law school based on those first year grades for the summer between my second and third years. Well, I did get a job, but it wasn't anywhere close to what I had wanted. But when I was interviewed by a partner of White and Case, he was the only one that then somehow took a personal interest in me and encouraged me, instead of sort of feeling, well, I can't throw the guy out of the room right away. I guess I got to be polite and interview him for 15 minutes or something. And this chap, his name is Lawrence B. Morris, and he is one of the 5 dedicatees of my book because he gave me a chance. He looked at me and he said, "You graduated cum laude from Harvard College?" I said, "Yeah, it was good enough for Jack Kennedy. I figured it was probably good enough for me. I didn't make Magna or Summa, but there it is." And he said, "And you had a Fulbright scholarship in Germany for a year. That's all pretty good. You must be able to do better." And I said, "I must be able to do better. I can't tell you what's happened this year. Some people have a hard time changing to law school from just plain college." So he said, "Look, we can't hire you now for the summer, but if you get your grade up to," and he gave me a number, I want to be the first one that you call." And well, I got it up there a little bit more. Actually, in the third year, I got it up even more. If those had been reversed, I might even have been on the law review, but that's not what happened. And I called him, and I spent I was working in New York. large parts of the summer having nice lunches at the Downtown Association with other partners at White and Case. And by the time the summer was over, even though I hadn't worked there in the summer, I was offered a position to come in as an associate. He saved my life. If I hadn't had that job to begin with, where would I have gone? What would have happened? So sometimes we benefit from the kindness of others. And he deserves a lot of credit. That's why the dedication, because he launched me. There it is. That's the answer.
That's truly amazing, Charlie. And thank you for sharing that with us. So in the chapter titled How to Sue a State, you discuss how opponents of international arbitration ask how the system can be fair when the parties can appoint whoever they want. And your answer to that is that arbitrators with obvious conflicts of interest are unlikely to be listened to in deliberations. You elaborate further that the challenge for a party is therefore not to find an arbitrator who will automatically agree with its case, but to appoint someone who will command the respect of the other two. Could you please elaborate on the art or the science, as the case may be, of appointing suitable arbitrators, particularly for junior lawyers like us?
Right. Well, addressing junior lawyers, of course, getting the first case eventually as an arbitrator is the beginning. How that happens varies. But I encourage you all to not be concerned that you don't get appointed as an arbitrator right away in your career. I have always had one rule for appointing, and that is whether you're appointing for the claimant or for the respondent, an arbitrator. Always take someone who, and it's more important, the bigger the case and the more political and the how much is at stake. I always said, appoint someone who, for whatever reason, will instantly enjoy the respect of whoever else is appointed. Whether it's the president or if you're appointing for the claimant, who's going to be appointed for the respondent. And the people who do the best and get the most cases over a period of time are those who are felt by parties and their lawyers to be straight shooters, look at the facts, look at the law, and make the best decision that you are minded to make. Now, as an aside, I was asked in the preparation of this book of mine to calculate how many times as a party-appointed arbitrator I had ruled against the party that appointed me. And it was 30% of the cases. And yet I kept being asked, sometimes by the same lawyers in particular, because they felt I was, well, there it is, that I was trustworthy, even if I might not find for their client.
Thank you so much for that very illuminating answer. So my next question is, could you please share with us your most memorable experiences at the Iran-United States Claims Tribunal and also at the International Court of Justice?
Well, let me start with the International Court of Justice, and I have to say, there's nothing that stands out except the entire experience of sitting on the court. And Jeremy mentioned David Karen, who was my first law clerk and became well, as most of my law clerks, lifelong friends. And we were sitting together on the International Court of Justice as judges ad hoc in two cases, both Nicaragua versus Colombia. They were different cases, separate cases arising out of a previous case that involved Nicaragua and Colombia. And so the ultimate experience, I guess, that David and I had before he unfortunately died at much too early an age, we had a common deliberation. There was one jurisdictional issue involving the Pact of Bogota in both cases. So the president of the court had a common deliberation of the two compositions of the court in those two cases. There were 14 elected judges. You would usually say 15 because there are 15 elected judges, but one of them had a conflict, couldn't sit. So 14 elected judges and 4 judges ad hoc, 2 in each case, were collected in the deliberation room. And David and I came out afterwards and said, it's not necessarily the outstanding, most collection of really top international lawyers. There are a lot of reasons for that. There are geographical distributions, and some of the judges have been domestic judges. They're not steeped in it, and they've had very different experiences. But I love the experience, and it really is. They may not be the top international lawyers of the world collectively, but it's a very interesting experience and one I enjoyed. However, the Iran-United States Claims Tribunal, that's easy. On the 4th of September, 1984, shortly after I had only been on there some months, 2 Iranian judges who in those early days were very revolution-oriented, physically attacked a 69-year-old Swedish judge, one of the third country judges, swung him around by his necktie, grabbed him around, beat him up, tried to throw him out of the building. That was an experience which I think has never been repeated anywhere I'm aware of in an international court or tribunal, although in some countries it's not uncommon in their parliaments from time to time. There's something to be said for the judiciary, I guess. I won't go on the whole story, but the bottom line is they were challenged by the United States. The president of the tribunal had a zany idea to how to keep them there, but eventually Iran withdrew them and sent new judges. And basically, the 9 judges by majority ruled that that was an acceptance by Iran of the challenge that had been made by the United States. Very memorable.
Indeed, very memorable. My next question is, you describe in your memoirs how your father once fired Ronald Reagan. Could you please tell us about that story?
Oh, yes. Well, that's pretty simple. My father, who rose from being a dirt poor boy and leaving home at 16, much later wound up with his face on the cover of Time magazine. And the Time magazine was because he was the chairman and chief executive officer of one of the handful of major advertising agencies in the United States, which eventually extended abroad. He got a call one day from the chairman and CEO of General Electric, which was a client. And the Ronald Reagan for years was on the GE Theater of the Air, introducing and talking a bit about whatever the show was going to be that day or that week. And he became very well known that way, actually much better than from his B-class films, basically, and Hollywood, which he didn't last there so very long. And the chairman said, the General Electric, of course, if you're going to fire somebody, you try and find somebody subordinate to you that will do it. So you don't wind up doing the dirty work. Well, my father was subordinate to him in the sense that GE was a client and my father was head of the advertising agency. What General Electric was saying was, he's supposed to spend all his time helping General Electric, but he's giving more political anti-communist speeches and so forth, and he's not doing what he should do for General Electric. So we want to get rid of him. Would you please do that? So actually, Ronald Reagan was in my father's office, and according to my father, had tears. He said, "What am I going to do? I'm all washed up in Hollywood, and I don't know what I would do next," and so on and so forth. But anyway, out he went, and seems he recovered. Eventually, years later, to finish that story, my father, still in the same position, was asked to sit on the dais at a big fundraising event out in California for the USO. And it happened he was seated right next to Nancy Reagan. And my father's thinking, I don't know how this is going to be. She might shred me. So he introduced himself. He said, "Mrs. Reagan, I'm Charlie Brower of Batten Barton, Durst and Osborne." And she looked at him and smiled and said, "Charlie Brower, Batten Barton. Ronnie and I ate off you guys for years, and it was so wonderful. We're so grateful for it." So anyway, that's that story.
Very interesting indeed. I would now like to turn to one of the challenges that you faced. In particular, you were considered for appointment as legal advisor of the State Department, but 6 senators tried to block it by sending a letter to President Reagan. You stated in your memoirs that perhaps I should have been flattered at how much firepower was thought necessary to shoot me down. Could you please share with us what happened and how you overcame this?
Right. I had received a call from a good friend of mine in the State Department. A lot of us who were in the Nixon administration wound up in the Ford or in the Reagan administration, or certainly wanted to return to government. And his friend called me. He was very tight with General Haig, who was the first Secretary of State in the Reagan administration. Said, "Charlie, how'd you like to be a legal advisor to the State Department?" And I said, "Well, I spent a number of months as acting legal advisor, but actually I think that's what I'm most qualified for. I'd love to do it." Well, then I didn't hear anything. I wasn't called for an interview, but the grapevine told me that some of us were being interviewed for the job. I had an idea of who some of them might be, and I wondered what was going on. And I got a call from the White House from another friend from the Nixon days, who was then now with Reagan, assistant to the president for congressional relations. He said, "Charlie, what the hell have you done?" "What? What do you mean? What have I done?" "I have a letter in front of me addressed to the president, signed by Senators Hatch, Helms, Humphrey, not Hubert Humphrey, but a one-termer from right winger from New Hampshire. Hatch, Helms, Humphrey, Goldwater, Laxalt, who had been the campaign manager for Reagan's successful presidential campaign, and McClure, who was another one-term right winger from Idaho, had one subject. Please do not consider appointing Charles N. Brower as legal advisor of the State Department because he opposed us when we, in the end of the Carter administration, were suing Carter. Goldwater versus Carter was the case. They tried to stop Carter from terminating the Mutual Defense Treaty with the Republic of China, known as Taiwan, basically. And at that time, I had gotten a call from this is in, there's an election camp. I think this is late 1979. I was called by a friend at the State Department who said, we can't go to court for ourselves. It's always the Justice Department. And this person who was in charge of treaty affairs said, there's a great argument that can be made for the president under the Vienna Convention on the Law of Treaties, and the Justice Department refuses to make it. Charlie, could you rustle up an amicus or maybe a couple of amici, represent them, and put this before the court? Well, I said, sure, of course. I did that. And the day before the hearing, which was in December, as I say, of 1979, it was supposed to be, the termination was supposed to happen on the 1st of January, 1980. And I get a call from the chief clerk of the court beforehand, said, Mr. Brower, will you be at the hearing tomorrow? And I said, try and stop me. Of course I'm going to be there. He said, well, I'm only calling because 2 judges of the court would like to ask you questions. Wow, what a gift for counsel for an amicus. Never happens. So I can't remember what the question was I asked, but I always operated as an professional advocate on the assumption that whatever they ask, I'll be able to say what I want, get it in there. Now, remember, this is December 1979, and as of the 4th of November, the month before, 52 American hostages were in the custody of the revolutionary Iran, the embassy having been overrun by alleged students and others. This is a big crisis, which in part led to the defeat of Carter when he was running against Reagan the next year. So I said, Your Honors, as we are convened here today, the President of the United States is confronted with an enormous crisis and wondering and working on what to do about it. One significant weapon he has in his quiver is termination, which he has the right to do under its terms, of the 1955 convention between between Iran, made under the Shah with President Eisenhower in 1955, Treaty of Amity, economic relations, and consular rights. And should the court confirm the judgment below, which was in favor of Goldwater and his people, it will have struck from the hands of the President of the United States an important weapon he has to consider in dealing with this crisis. Well, in the opinion, they didn't say anything about what I said, but they overruled the lower court. I think certiorari was denied, and in any event, the Goldwater people lost. So they were not too happy. So what to do? I was being buried alive by people in my own party at that time. There was a second paragraph saying, well, in law, the sea matters. He's also weak on deep sea mining, which helped give me a clue or confirm my belief as to who had done this. So how to get out of this? Well, in 1976, I had been on the President Ford strategy team at the convention, Republican National Convention at the Kemper Arena in Kansas City. And after a week of working with the platform committee, then came the week of the sessions in the evening of the convention. During the day, I was writing speeches that might or might not be given, depending upon what happened on the floor in the evening. And then we'd watch the convention. Well, I was 40 at the time, wondering why I'm walking around with this fat walkie-talkie. We didn't have iPhones yet in those days. We would be sitting up in the skybox with Henry Kissinger, Nelson Rockefeller, Bill Scranton, former governor of Pennsylvania, who had been a presidential candidate at some point, so on and so forth. And also Dean Birch, who had been Goldwater's campaign manager nationally in the 1964 campaign that Goldwater, of course, lost. So I'm thinking, I think I can call Dean. We happen to live in the same block in Bethesda with one house between our two families, and our little girls were attending the same walking distance local elementary school. So I called up Dean. He took it. He had been chairman of the Federal Communications Commission, and I think at this time he was running another organization. But he was very cordial. I told him what happened. He said, Charlie, Dean wouldn't do that. That is a staff job. And if you've been around the Hill, and I have, I worked for a senator from New Jersey when I was in college. Staff members can get people to sign almost anything. And I instantly, by intuition, knew who it was in Goldwater's office because I had dealt with that person. And I was sure who stimulated that person to try and torpedo me. He said, look, that's a staff job. He's a staff job. And I said, Dean, you know it. I know it. And I'm sure I know who's responsible for it and who did it in Goldwater's office. What I need is another letter. Senator Goldwater is enough to the president saying, well, that was that, and for that reason, but he's worked in the Nixon administration. He's been acting legal advisor, and he's known to be very supportive of American investment abroad, and so he would be eligible for some job in that area. So Dean said, okay, call this staffer in Goldwater and Barry's office, get together with him, show him the letter you want the senator to send, and I'll talk to Barry. And if there's any problem, just let me know. I got the letter. Then I made an appointment with Penn James, who was the assistant to the president for appointments. I walk in, and he says, well, about this legal, forget it. I was not born yesterday. There's a letter like that in the file. I'm not going to be a legal advisor. Okay. Now let's talk about something else. And of course, my next choice was the Iran-United States Claims Tribunal. Well, by the time the decision for a vacancy on the Iran-United States Claims Tribunal was to be made, Everybody I knew in town knew what had happened, thought it was disgusting, the revolution eating its child, and everybody from the deputy attorney general, who happened to have been a partner of White and Case before and after that. And I wound up sitting in the office of White House counsel, whom I also knew from the Nixon administration. He said, "Charlie, I want you to get this job." Great. I got it. And final note, it turned out to be, had I been legal advisor, I would have had to consider whether or not to resign when in 1984, Nicaragua went after the United States for its assistance to the Contras. And when jurisdictional objections by the United States were refused by the court, orders came from somewhere saying, we will not participate in that proceeding anymore. We won't show up for the merits. This is terrible. And furthermore, the administration is withdrawing. It's shortly after after the end of the Second World War, acceptance of the compulsory jurisdiction of the International Court of Justice in all cases, a real blow to international law. And the person who had become legal advisor had married into the Bush family, and is a good friend, actually helped me out later in other matters, and still asking himself, should I have resigned as legal advisor or not? I would not have wanted to be in that position, and I made a much greater career having been acting legal advisor for months by being all these years at the United States Claims Tribunal. So that's the story of, Lazarus digging himself out of wherever he was.
That was really a perfect example of how to resurrect oneself when ambushed. So thank you for sharing your gems of wisdom.
Don't lose courage. Just embrace the situation and figure it out.
Thank you for that. Now, turning to the Herbert Smith Freehills' ISDS Policy Trend Roundup for 2023. Now, that reports on investment treaty arbitration filings. In particular, it states that in 2022, 56 new cases were publicly filed, although the number is likely to be higher as some treaty arbitrations outside ICSID or the PCA will be confidential. In relation to 2023, while these numbers are yet to be finalized, UNCTAD public records for 2023 suggest that 35 new cases were publicly filed last year. If correct, this would show a continued decrease in treaty claims. What is the impact of this on peacemaking, which is what international dispute resolution promotes, as stated in your memoirs? And could you please share with us your defense, as you've also elucidated in your memoirs, of the system?
We are really facing a terrible situation, partly because the European Union, which began as an internal within the member countries' economic situation, now with 27 countries, has become a wannabe imperial power by forcing its view of ISDS, as it were, investor state arbitration, on the rest of the world. How? It is in working group 3 of UNCITRAL. I can't tell you how many keynote addresses, endowed speeches, and sounding off as an observer in some earlier meetings of working group 3, I have attacked the EU idea that get rid of the system in which the claimant and the respondent each name an arbitrator, and then by a mutual process, you wind up with a chairman or president of the tribunal. They want to have a 15-member international investment court with an appellate phase also, all by judges, as they call them, appointed by states, or potentially, on how things go, possibly by international organizations. But it's all one-sided. The investors who control international investment don't get a role. They don't have an equal role. They don't have any role at all. Now, unfortunately, in several treaties, including the one the Commission, I'm sorry, the EU did with Canada, also, I think, Singapore now, and another one, I think it was Vietnam, they basically forced into these treaties an acceptance of that kind of situation. And I remember very well my good friend Marc Lalonde, unfortunately now deceased, who was the chief of staff and then held 4 different ministerial portfolios in the government of the father of the present prime minister in Canada, stated publicly, well, Canada just wanted to get the trade provisions in the treaty and swallowed this investment court system in order to get it. Investors will not like it. They don't like it, but it seems to be maybe a losing game for investors. We'll see. This is Working Group 3 has been going on, and I think UNCITRAL was outrageous in accepting the EU view that the sought-after convention establishing this will be negotiated in UNCITRAL Working Group 3. UNCITRAL always was a bunch of non-political, impartial technicians, experts, not government officials, putting out the UNCITRAL arbitration rules, or the model law on arbitration. This, however, it turns out, if they don't get it, fine. If they do, it will be, it's already international ISDS has been eliminated by the European Union for member states. That's done. And so then it will be any convention that comes out of that will be binding on EU member states. Then the question is, who is going to opt into that, which would be available for opting into, and then it'll be a war of fighting these people. Now, I think all of this is one reason why it's gone down. Also, many states have, I've sat in a couple of cases that had the results of the state, India in a particular case, of basically terminating as many bilateral investment treaties as possible, begging to other states to revise the bits that could not be terminated so readily. And even the United States, I'm sorry, model treaty is now much weaker for investors than earlier bits that have been concluded. So this is a big fight, usually fought by. I gave a keynote speech on this for Washington Arbitration Week, and I'm giving another one next week over dinner at the University Club in New York City. you've got United States senators, particularly the woman from Massachusetts and Senator Whitehouse, I'm sorry, from writing letters to the Secretary of State and our chief trade officials saying, get rid of ISDS in all treaties. It's just a way for corporate monsters to be bullying poor little countries that and to earn high rates of return on their cases. I guess my position is pretty clear.
Thank you so much for that, Charlie. Now, my final question is, what is the legacy that you would like to leave behind?
Right. Well, it is, I don't think I'm thinking of anything other than what I think would happen. We don't necessarily have control over our legacy, but leaving aside the books and writings and opinions and judgments and opinions otherwise connected with judgments or awards. It's basically, it's like any family. What you leave behind is your children. I've had a lot of people like Jeremy who have clerked with me and associates at the law firm. And frankly, my former clerks and the people I've worked with, some as interns with me here at George Washington Law School, it's whatever you have taught them, they've learned, they've carried forward. That is the natural legacy. And unless you're Abraham Lincoln, who won the Civil War, it's who will always be remembered. It's whatever you leave behind, and I think I have a very satisfying legacy in the people that I've worked with and who will go on and carry the same flag and hopefully, yeah, do good in the ways I hope that I have done.
Thank you for that really beautiful answer, Charlie. So I'd now like to open the floor to our audience. If you have any questions, now's the time to raise your hand. So we have one audience member here. If you could introduce yourself by name and the organization you're with, followed by the question.
Certainly. Good evening, Judge Brower. Good morning, everyone. My name is Hugo Petit. I'm an associate in the International Arbitration Group here with Hogan Lovells. Thank you so much for your remarks and for taking the time with us today. I had a question that came to me while listening to several of your remarks about the intersection of law, but especially as we've been discussing international law, international public law, or investment treaty law and politics. And the question came to my mind at several points in your remarks. You spoke about how UNCITRAL used to be experts, but the political forces are taking over. You spoke of the United States rejecting compulsory jurisdiction of the ICJ, and you talked about how, as a legal advisor, you would have queried whether to resign or not. So I take it that was quite a political decision that was handed down to the lawyers. But the first point when the question came to my mind is when you said that when you were arguing before the court in favor of rejecting, or which way was it, of overriding the lower court to enable the president to keep the tools of terminating the treaties or not, You said the court eventually addressed other arguments in their opinion, but the arguments you made sounded political in the sense that it was a policy tool you argued should stay in the hands of the President of the United States. So what are your views on, at this level of international law, how politics actually play into the application of the law, and how black letter legal oriented should we be when actually it's all policy considerations, or is it all policy considerations?
I'm sorry, could you repeat those last words? Is it all?
Is it all or not policy considerations rather than whatever law is in the textbook?
It's a very thoughtful question. You're obviously dealing with someone who's been involved in politics quite a bit. I actually began in my home state of New Jersey in an elective political career, and which is one of the reasons, and I'd been elected to local office, and it was one of the reasons I went off to Washington. But after the 4 years at the State Department, and I was shanghaied by the Assistant Secretary for Congressional Relations to help him, because Senator Fulbright was loading a lot of legal issues on him, which he had no answer to, because he was a West Pointer with a combat record and a PhD in history, but not a lawyer. And you spend enough time meeting all those people and seeing how their life is lived, and so on and so forth, and how chancy it can be in politics. I decided I'd stay in Washington, practice law, and do the sort of involvement in politics that you get into in Washington if you have the right friends and connections. It is, look, any case has to be decided on the law and to the extent a determination of the facts, if there are factual issues. But for an example, ISD cases are always political. They're always political. You're dealing with a state that made a decision that is being attacked. And so the government is being attacked. Their internal politics. Every case involving a state has an enormous political background and aura around it. It's not like a commercial case between two companies over a contract. So it is, I think, look now at the case before the United States Supreme Court to forbid Trump from being a candidate for president based on the Part 3, Section 3 of the 14th Amendment. You don't think the Supreme Court is thinking, the judges there will be thinking about the impact of
It's 9 o'clock.
the decision either way? It is, you're in a political environment, and ISDS cases are there. There are a lot of strange things that go on, obviously, from time to time. But it is, one necessarily is conscious of the potential consequences of the decision. It should not affect the decision, but it's there in the room. It's you can't get it out of your mind, but you should not be swayed by it. Now, what I said before the United States Court of Appeals for the District of Columbia in Goldwater versus Carter, I felt was important. The reality is that the treaty itself had a provision for termination, and it had been obviously ratified, or advice and consent to ratification had been given by the Senate. There wasn't really, Goldwater didn't have a case with decent judges considering the terms of the treaty itself, which provided for termination by either side on a particular schedule, which had been met. but I think it is significant. And in many trials, this will come up, criminal trials as well as civil cases. People do think of the consequences, and they should think of the consequences, not be affected in their decision by them.
Thank you.
I'm obviously conscious of the time. If we have any last questions. Okay, so I think I will wrap up this fireside chat by saying thank you very much to Charlie for his valuable time and his wonderful and insightful advice and sharing of experiences with us. And also thank you very much to Jeremy for his introductory speech. And thank you everyone for coming. And thank you, a special thank you to Twenty Essex for sponsoring this event. I think everyone in the audience here is also really grateful for your valuable time, Charlie. So thank you very much again.
Well, thank you for the opportunity.